Question number 451. A lets a house to B at yearly rent of rupees 12,000. The rent for the years 2015, 16 and 17 is due and unpaid. A sues B in 2018 only for the rent due for the year 2016. Whether A can afterwards sue for the rent due for the year 2015 and 2017. Option A, yes. B, no. C, if he shows good cause, and D, none of the above. Here correct answer is option B, that is no. Question number 452. Which provisions of the code deals with the joinder of causes of action? Here correct answer is option A, that is order 2 rule 3 of CPC. Question number 453. Which of the following tests are to be applied in cases where the plea of bar of suit order 2 rule 2 is raised? Option A, where the cause of action in the previous suit and that in the subsequent suit are identical. Option B, whether the relief claimed in the subsequent suit could have been given in the previous suit on the basis of the pleadings filed in the suit. C, whether the plaintiff omitted to sue for a particular relief on the cause of action which had been disclosed in the previous suit. And option D, all of the above. Here in question number 453, correct answer is option D, that is all of the above. Question number 454. A plaintiff, option A, cannot unite several causes of action in the same suit. Option B, can unite several causes of action in the same suit against the same defendant. C, unite only some causes of action in a suit. And D, unite only the questions of law in a suit. Here correct answer is option B, that is can unite several causes of action in the same suit against the same defendant. Question number 455. Which of the following is not a ground for the court to order separate trials under order 2 rule 6 of CPC? Option A, delay in the trial. Option B, embarrassment of the trial. Option C, inconvenience. And option D, none of the above. Correct answer here is option D, that is none of the above. Question number 456. Multifariousness means option A, misjoinder of the causes of action, misjoinder of parties, non-joinder of parties, misjoinder of causes of action as well as parties. Correct answer here is option D, that is multifarious means misjoinder of causes of action as well as parties. Question number 457. The plaintiff wants to claim some reliefs in a subsequent suit. He requires to leave under which of the following provisions of the CPC? Here correct answer is option C, that is order 2nd rule 2 clause 3. Question number 458. Several persons can be joined as plaintiffs in cases option A, where the right arises out of the same act in favor of such person. Option B, where any common question of law is involved. Option C, both A and B. And option D, none of the above. Here correct answer is option C, that is both A and B. Question number 459. Which of the following deals with the service of process on pleader in the Code of Civil Procedure? Option A, order 3 rule 5. Option B, order 2 rule 2. And option C, order 7 rule 3. And option D, order 4 rule 8. Here correct answer is option A, that is order 3 rule 5 of CPC. Question number 460. Under CPC, every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in his behalf. This is provided in, correct answer is option D, that is order 4 rule 1 of CPC. Question number 461. Under order 4 rule 1, sub rule 1 of CPC, a suit is instituted when option A, a copy of a plaint is presented to the court, a plaint in duplicate is presented to the court. Option C, a plaint in triplicate is presented to the court. And option D, the court taken the plaint in consideration. Correct answer here is option B, that is a plaint in duplicate is presented to the court. Question number 462. Rule as to issue and service of summons in CPC are laid down in order 5, order 7, order 8, order 11. Correct answer is option A, that is order 5. Question number 463. Order 5 of CPC provides for issue and service of summons. Correct answer is option A only. Question number 464. Summons of a suit cannot be served by. Options are service in person on the defendant. Option B, sending the summons to the residence of the defendant. Option C, through publication in the newspaper. And option D, sending the summons to a friend of the defendant. Correct answer here is option D, that is sending the summons to a friend of the defendant. Question number 465. Under CPC, a copy of plaint shall be attached with every summons. Is not necessary to attach with every summons. May be attached with the summons when the court permits. Is attached with summons on the request of the plaintiff. Here correct answer is option A, that is shall be attached with every summons. Question number 466. Where a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and may be served on such day not beyond dash from the date of institution of suit. Here correct answer is option B, that is 30 days from the date of institution of suit. Question number 467. A defendant under Order 5 Rule 1 Clause 1 of CPC is required to appear, answer the claim and to file the written statement. Option A, within 90 days from the date of service of summons. Option B, within 60 days from the date of service of summons. Option C, within 30 days from the date of service of summons. And option D, within 15 days from the service of summons. In question 467, correct answer is option C, within 30 days from the date of service of summons. Question number 468. The court may also permit service of summons by the plaintiff in addition to the service of summons by the court by Order 5 and dash of CPC. Here correct answer is option B, that is Rule 9A of CPC. Question number 469. Thus the summons for service on the defendant can be given to the plaintiff under. Correct answer is option A, that is Order 5 Rule 9A of CPC. Question number 470. Under Order 5 Rule 9 Clause 3 of CPC, the expenses for the service of summons to the defendant have to be borne by. Option A, the plaintiff is the correct answer. Question number 471. Which of the following statement is incorrect? Option A, where there are more defendants than one, service of the summons shall be made on each defendant. Option B, service of the summons shall be made by the tendering a copy thereof signed by the lawyer. Option C, summons for the defendant cannot be served on a servant. And option D, defendant may empower agent to receive summons. Here in question number 471, correct answer is option B, that is service of summons shall be made by the tendering a copy thereof signed by the lawyer is incorrect. Other options, that is when there are more defendants than one, service of the summons shall be made on each defendant is right. Summons for the defendant cannot be served on a servant, this is also right. And last option, defendant may empower agent to receive summons is also right. Question number 472. Where a defendant was avoiding service of deliberately, the court orders service by advertisements in a newspaper, but it did not order to affix summons in the courthouse or at the defendant's house also. The procedure adopted by the court is regular, irregular, improper, and justified. Correct answer is option A, that is regular. Question number 473. Which of the following is recognized mode of service of summons under CPC? Option A, personal service to the parties or agent, service of summons by the court, substituted service of summons, all of these. Correct answer here is option D, that is all of these. Question number 474. When the defendant is absent at the time when the service of summons is sought to be effected on him at his residence, there being no likelihood of his availability within a reasonable time and in the absence of an empowered agent, the service may be made on. Option A, any adult male member of his family. Option B, any adult female member of his family. Option C, a servant engaged by the defendant at his residence. And option D, both A and B. Here correct answer is option D, that is both A and B. Any adult male member of the family, any adult female member of his family. Question number 475. Where the person summoned cannot by the exercise of due diligence be found, summons may be served. Option A, by affixing the same on the notice board, municipal council or gram panchayat as the case may be. Option B, by leaving one of the duplicates of the same for him with some adult male member of his family residing with him, and the person with whom summons is so left is so, if so required by the summoning officer, sign a receipt therefore on the back of the other duplicate, by affixing the same on the conspicuous place of his house. And D, by serving the same on the servant of the person summoned and obtain from him the acknowledgement thereof on the back of the duplicate. Here in question number 475, correct answer is option C only, that is by affixing the same on the conspicuous place of his house. This is the right answer. Question number 476. When the defendant is confined in a prison, the summons shall be served by affixing outside the prison, by sending process server in the prison, by delivery of the summons to the officer in charge of the prison for the service of the defendant, by production warrant through the court. Here correct answer is option C, that is by delivery of the summons to the officer in charge of the prison for service of the defendant. Question number 477. Where the serving officer delivers or tenders a copy of summons to the defendant personally or to his agent, he must require such a person to sign an acknowledgement of service to be endorsed on the original summons. Then option A, the copy of the summons will be delivered to the defendant. Option B, the original summons with the defendant's signature thereon will be returned to the court. Option C, both A and B. And option D, the original summons with the defendant's signature thereon will be returned to the plaintiff. in question number 477? Correct answer is option C, that is both A and B. Question number 478. During service of summons, defendant was found absent from his residence and within reasonable time no chance to get back at his residence. Service of the summons may be made on servant, minor daughter, adult son, munim. Here correct answer is option C, that is adult son. Question number 479. Where the suit is instituted against a corporation, the summons may be served on the secretary, on the director, on any principal officer, any of these. Correct answer here is option D, that is any of these. Question number 480. Pleading has been defined in option A, Order 6 Rule 1 of CPC, Order 6 Rule 2 of CPC, Order 8 Rule 1 of CPC, Order 8 Rule 2 of CPC. Correct answer here is option A, that is Order 6 Rule 1 of CPC. In Order 6 Rule 1 of CPC, pleading has been defined. Question number 481. The forms in dash, when applicable and where they are not applicable, forms of like character as nearly as may be shall be used for all pleadings. Correct answer here is option B, that is Appendix A. Question number 482. Pleading means plaint or rejoinder, plaint or written statement, plaint or written statement or rejoinder, plaint alone. Correct answer in question number 482 is B, that is plaint or written statement. Question number 483. Pleading should state material facts, law, the evidence, any facts. Correct answer here is option A, that is material facts. Question number 484. Which of the following are the fundamental rules of pleading as set forth under Order 6 Rule 2 of CPC? Here correct answer is option D, that is all of these, which means option A, every pleading must state facts, not law only, is correct. It must state material facts only is correct. It must state such facts in concise form only is also correct. Question number 485. What is the essence of pleadings? Option A, plead facts not law, plead law not facts, plead facts and law, all of the above. Correct answer is option A, that is plead facts not law. Question number 486. CPC pleading does not include plaint, written statement, evidence, material facts. Correct answer is option C, that is evidence. Pleading does not include evidence. Question number 487. A bundle of facts which taken with the law applicable to them gives the plaintiff the right to relief against the defendant. It is called plaint, written statement, cause of action, none of these. Here correct answer is option C, that is cause of action. Question number 488. No evidence is required to be pleaded in written statement, writ petition, counter affidavit, all of the above. Here correct answer is option D, that is all of the above. Question number 489. Which one of the following is not a rule of pleading? Option A, plead the fact and not the law, state the law and plead the facts, plead material facts only, plead facts not evidence. Correct answer is option B, that is state the law and plead the facts is not a rule of pleading. Question number 490. With regard to pleading under CPC, choose the true statements about the propositions. Propositions are: pleading should state facts and law. Second, facts stated in the pleading should be material facts. And third, pleading should not state the evidence. Here correct answer is option B, that is second and third are correct and first is incorrect. Question number 491. Factum probandum means. Correct answer is option D, that is the principal fact to be proved. Factum probandum means the principal fact to be proved. Question number 492. Which of the following need not to be stated in pleading? Option A, statement of material facts, effect of a document, burden of proof, particulars in case of fraud. Correct answer is option C, that is burden of proof. Question number 493. Pleading must be signed by the party, by the pleader and the party both, by the pleader and the successor of the pleader. Correct answer is option C, that is by the pleader and the party both. Question number 494. In which order and rule of CPC the provisions for verification of pleading is provided? Verification of pleading is provided under Order 6 Rule 15 of CPC. Question number 495. Under Order 6 Rule 16 of CPC, pleading can be struck on the ground that it is scandalous, unnecessary, vexatious, all of these. Correct answer is option D, that is all of these. Question number 496. The court may strike out any matter in any pleading Option A, which may be unnecessary, scandalous, frivolous or vexatious, which may tend to prejudice, embarrass or delay the fair trial of the suit, which is an abusive of the process of the court, and all of the above. Correct answer is option D, that is all of the above. Question number 497. Pleading can be altered or amended. Option A, under Order 6 Rule 9, option B, Order 6 Rule 10, option C, Order 6 Rule 16, and option D, Order 6 Rule 17 of CPC. Here correct answer is option D, that is Order 6 Rule 17 of CPC. Pleadings can be altered or amended under Order 6 Rule 17 of CPC. Question number 498. Under which provision of the CPC it is necessary for a party to prove that in spite of all due diligence, the matter could not be raised before the commencement of the trial? Correct answer is option B, that is Order 6 Rule 17. Question number 499. Under Order 6 Rule 17 of the CPC, the court can allow to alter or amend the proceedings to either party, to plaintiff only, to defendant only, to only one defendant if there are more than one defendant. Correct answer is option A, that is either party. Question number 500. Voluntary amendment is provided under option A, Order 6 Rule 7 of CPC, Order 6 Rule 15 of CPC, Order 6 Rule 17 of CPC, Order 6 Rule 19 of CPC. Here correct answer is option C, that is Order 6 and Rule 17 of CPC. Voluntary amendments are provided under Order 6 Rule 17 of CPC.